for the petitioner and Miss for what more I forgot. What it's for what two, right? Your first name?
One S4.
S4 learned counsel for respond number
1, 2, 3, and
1, 2, 3, and
Elementary
4.
department.
1, 2, 3, and 4. All the 4. Yes, block elementary education is 4.
it's okay.
1, 2, 3, and 4. Miss K. Fukon, learned counsel appears for respond number
6.
6. Pension.
Yes,
Pension.
No, 6 is pension.
Yes, yes.
And who else?
80.
So and so for B. Sharma for respond number 5. Oh. It is noticed in the instant case that the respondents have not filed their counter affidavits for a period of 2 years.
4 years.
22,
22,
right?
22 at
For a period of 3 years.
3 years.
And the matter is still pending for non-filing of the same. As such, the respondent authorities are given the last opportunity to file their affidavits. Otherwise, this court will proceed to the other matter. List this matter on. This is the last chance, and this is immediately after the vote. Okay. List this matter on 22nd of April,
For admission hearing.
on which date the matter will be heard and disposed of.
Obliged.
Seven to 9. Mr. S.P. Chaudhary, who appears for health? Nobody from the health department? Petitioner, respondent, no one is there? D. Upamanyu, I think he appears. Call it after some time. Yes, 10.
My lord, can you finish the last program?
Your Lordship, I have received my instructions yesterday, Your Lordship.
Because last time one instruction was placed and it was not graspable, not
Yes, Your
understandable.
Lordship. Yesterday I have received one more instruction, Your Lordship.
Mm.
There it says that the matter is pending with the Directorate of Pension.
It's in your mobile. You don't have a hard copy.
No, Your Lordship, it was sent last night.
So what do you say? It is in the Department of Pension. The
Yes,
process is on.
Yes, Your Lordship.
It is being processed. Yes, Mr. Chaudhary, your matter, I've kept it pending. I mean, after some time. Yes.
Last occasion, GPQ appeared on behalf of the director pension.
GPQ appeared for respond number 4.
Yeah, director pension.
But then her instruction is that matter is being processed.
Even in fact, Your Lordship, the original service book has not been written yet from the Office of the Director, Your Lordship.
Acha, this is the instruction is from inspector.
Yes,
of
Your Lordship.
schools.
Inspector of School, Your Lordship.
With the entire instructions.
Here it says that the original service book has not been written yet by the Director of Pension. Nor.
So original service book will be written by pension department.
Yes,
By the
Your
director.
Lordship. Yes.
And what else?
Nor complied with the Honorable High Court order, the High Court order dated 13/8/2018, Your Lordship.
So there was an order by the High Court and that was not
Yes, yes,
complied with.
yes. That
So this
matter
is
was
the
already
instruction,
settled.
Hmm?
That matter was already settled. The Honorable High Court has directed the respondent authority to sanction the special family pension. That order was passed in the year 2018. Thereafter, the director pension, what happened while the content case was deferred, the director pension has purportedly submitted a compliance report. That was vague. There is nothing, no complaints, just they have changed the name from family pension to special family pension, but no another monetary benefit. Thereafter, again another content case was placed, that was also closed. Subsequently, this petition was filed. The order is already there, madam. Kindly come to page 31 for a moment. You'll also find the property portion. Page 31.
Page 31.
Yes,
Hmm?
property portion 20,
Yes.
29.
Hmm. Okay, this was not followed.
Not good. My lord, what?
Earlier I am present, nothing is paid.
Nothing, nothing. She is getting her regular pension at the rate of only 6,000. And she is, if family pension is special family pension is granted, she will get around 60 to 70,000 salary, regular salary of her deceased husband. That is special family pension. Now, what she is stating,
Special family pension is what?
this is, if a husband of a deceased employee dies in the discharge of her duty, then she will get the
Salary.
regular salary till the date, actual date of retirement.
Mm.
Thereafter, regular family pension will follow.
Mm.
Now, in this case, my lord, her husband died in the year 2004.
Mm.
Thereafter, my lord, they have sanctioned only simple family pension, not special family pension. Her husband was killed by the extremity.
Mm. Till he was supposed to retire when?
In the year 2034.
2034.
34. Yes.
He was a boy, young boy.
Yes. Now, that what her instruction is repeating, that is again, my lord, again, that process, that they are seeking the original service pension book from the DFA pension. That has already in several earlier orders, my lord, the law will find that part is already over. They are saying that we are reconstructing the service book. Now they are finding the unpaceable matter. It is totally unfortunate because the service book cannot be unpaceable because pension is granted on the basis of service book. Now petitioner is suffering, my lord. Ultimately, what will happen?
No, that special pension was also not given to her since
No, no, no.
2004.
No. Only family
2004 he died.
Yes, yes.
So since 2004, nothing is paid to
No,
her.
no, only family pension.
Only family pension
Yes,
is
yes.
paid. That is half of his salary or whatever.
Yes, yes.
That is paid to her since 2004,
It is no family pension, special family pension.
but no special family pension.
My lord, they are ignoring the
So
paragraph.
how can that file be lost? Because she was paid family pension.
Yes, because family pension was paid. Now they will devise the special family pension on the basis of the service book, what their salary will be written. What is the last salary? Because pension is sanctioned on the basis of last 10 months average salary.
Mm.
And that since the family pension was sanctioned, they definitely that was based on the service effort.
That is why they
Yeah.
say that the file is lost.
Yes, yes. How
Now,
they can say?
they said that the file is lost, they have reconstructed.
Yes, that reconstruction part is going on from 2023. They are reconstructing. They are shifting their liability from one to another.
Have you filed affidavit? Affidavit you have not filed, right?
Nothing. My lord,
Your now instruction is that the service book is not
Not with us, your
Me.
lordship, it's in the, with the pension department, your lordship.
this will not do.
now what will happen? Ultimately, paragraph 29, your lordships, each lordship goes. Yes.
So what happened to the contempt proceedings?
Contact person is closed. Liberty was granted.
Closed in what manner?
Well, court sometimes they submit some instructions, whether complied or not, properly complied or not, they say comply. On the basis of compliance, they say contact process closed.
But it is not complied.
Not complied.
I mean, the special pension was not paid.
Not. I have submitted the salary pension statement, page 39. He's getting only 6,000 something.
Acha, we will take it for admission hearing next week. You bring proper instructions. This will not do. This
No,
half-heartedly Instruction will not do, because you cannot say that the file was lost. She was given pension, family pension. The wife is before the court,
Yes, yes.
and then she is getting it. Now reconstruction, a file is not there, you cannot bring proper instruction. And we will take it up and dispose the matter next week. On second, not second. Yes, on 2nd of April.
My lord, what will happen ultimately is what they are saying, my lord, they will have to bear the interest also.
Ah, they have to
They
get it.
only to bear 2004, my lord, how much it will cost? The district is lying silent.
Okay, heard Mr. S. Hawk, learned counsel for the petitioner, and also Miss
H. Terangki,
H. Terangki, learned government advocate, what? You are for?
Secondary Department, Education.
Second, for standing counsel for secondary education. Miss Terangpi, learned, and Miss K. Fukan for response number 4. Miss K. Miss P. Terangpi,
H.
H. Terangpi, learned counsel for secondary education, has placed an instruction which says that the file has not been signed or what?
No, your lordship, it's not with us, it's with the pension department. Your lord.
No, the instruction says what?
It says that the,
They put the printer.
they are,
It's okay, you tell me.
lordship, here it says that it's pending with the director of pension.
The pension, file,
Serving,
the concerned file,
serving.
the service book, yes, the service book is pending.
In the pension, the director of pension.
How can it be pending for the director?
No, your lordship, it says that the matter is pending with the director of pension. This is the sentence they have.
Has placed an instructions which says that the matter is pending
In the
before
pension.
the directorate of pension. And what else?
And the file had, the service book has not been written yet, your lordship.
Written,
Returned.
and that the service book has not been returned by the directorate of pension.
Yes, your lordship.
By the directorate of pension. However, the said instruction doesn't satisfy this court, inasmuch as the fact of the case is the petitioner's husband died in the year 2004. During his service.
No, whether it was killed in the year 2004 by extinguished. Died.
It will have different connotations.
No, that died.
Dying in harness, he will.
Yes.
Okay, died so and so. And under the law, the next of kin has to receive the special family pension till the date of his retirement.
If I am not wrong, if your lordship rights died, Norbert died in harness, then family pension, if institutional family pension is to be given, then it must be killed by extinguished.
So the petitioner was killed by the
Petitioner's
extremist.
husband was killed by the extinguished.
The petitioner's husband was killed by the extremist, huh? Died during his service. During his service, killed by the extremist during his service. It is the next of kin is entitled to get the special family pension. But till date, only family pension is given to the next of kin, but no special family pension.
Despite of the honorable court's order dated
Despite the honorable court's order dated
13/8/2018.
page 31, right?
Yes, my lord, it starts from 21.
Dated 13/8/2018.
In WPC number 4345 of 2015.
In WPC number 4345 of 2015. It is accordingly directed that the learned counsel for the standing counsel for the education department would get proper instruction from the concerned authority and the matter be listed for admission hearing on when? On 6th of April,
Yes, your lordship.
6th of April, on which day the matter will be disposed of.
I'm open.
You bring proper instruction, otherwise I'll dispose of. So,
Definitely, your lordship. In this matter, lordship, pleadings are completed. It's a matter may be list for pleadings completed.
As per record, reply has not,
what did you say?
as per him, my lord, pleadings complete, my lord, but as per record, reply not filed, my lord. And we also, we have not received any reply. They are claiming pension, my lord.
Hmm.
We are specifically denied, my lord, they are not eligible for pension. We have filed our detailed affidavit also, my lord.
So you will find reply or we will proceed.
You know, reply is necessary, otherwise they cannot survive, my lord.
Lordship, matter may be taken after some time, lordship. My,
Because there is a judicial order saying that if the affidavits are not filed, then court will proceed.
after some time, matter may be taken up, lordship.
Yes, you will file reply or we will proceed.
They
It's necessary.
have filed affidavit. So, your lordship can fix a date for hearing.
You will file reply or not?
On a hearing that may fix, my lord. They are not going to file affidavit, reply.
It's okay. We will proceed with whatever pleadings we have.
Or we are suggesting, my lord, if possible, my lord, on a hearing date, my lord, we have some other matters. Because I was expecting that they will file affidavit, reply.
You are for respond number
I'm
3.
for PNRD department.
Okay. Heard Mr.
DA Kaim.
G.A. Kayyum, learned counsel for the petitioner, and Mr.
As doctor for the
Yes.
standing council, PNRD department.
Standing counsel, PNRD department. Mr. The learned counsel, yes, you are for
Respond 6, my lord.
respond number 6, Arthi Talukdar, and T.C. Chitia for respond number 1. The learned counsels for all the parties submits that the matter is ready for hearing and be listed for admission hearing
Any
Hearing,
hearing?
on hearing, a hearing.
Hearing.
Matter may be listed for hearing on this date. I'll give you a
On
date
vacation, any day.
on 23rd of April.
Right. I love you.
It's a Thursday. Acha, Mr. B. Gogol for respond number 5.
I love you.
Yes, Mr. Chad.
May I please, Your Worship? In this case, the petitioner is challenging the major punishment that has been imposed upon him.
Hmm.
That's a. The other two writ petition is also with regard to the same set of allegations.
Hmm.
Now, what has happened, Lordship, in this case, there's a.
Who's for the health?
It's a health department, Lordship.
Mr. Chutia, oh yes, Buddha.
After some time, we will also go to watch.
Mr. Upperman is there. Okay, after some. Mr. Chalima,
Listeners were. And are. That's as employees.
not filed their affidavit.
They have not filed their
Not filed nothing, but metal do in the law point.
law point.
Law point.
Affidavit is not required
Not required.
because
Otherwise, 23 matters. Huh?
Yes, sir. Because Lordship
yeah.
Otherwise, it is a long pending matter, say.
Yes,
Literally.
yes. So
You get
23.
instruction, no need to file affidavit. Okay, heard Mr.
Yes,
D.P. Choliha, learned counsel for the petitioner, and Mr.
in Pathar for
and
irrigation department.
learned counsel for
Irrigation department.
irrigation department, and Mr. B. Gogoi for health, for finance department. Mr. Gogoi submits that on the next date fixed, he will bring the written instructions in respect of the instant matter and has prayed for some time. Prayer is allowed. List this matter on not very long. List this matter on 24th of April, on which date Mr. D. Gogoi will place the instructions without fail.
Alright.
What is the lordship? Small matter, my lord. Here, basically, this the difference in the grade pay. There is already, yes, my lord, there is always
Pleadings are over.
other pleadings are over. It is more, in fact, my lord, there is an order of this honorable court, which your lordship will find page, it starts at 17, my lord, 18, paragraph, I mean, page 18. Similar
1/8.
1/8, my lord, of the writ petition. Order date is 16/8/2016. You know, we are in the same footing.
No, page number 18.
18 of the writ petition, my lord. Lordship is taking up item 15,
Huh.
18. It started
16 order.
no, 17 if a lordship annexed 2. That is the order.
2016 order.
Yes, 2016 order. Basically, we are in the same footing as that of the petition in that case.
Hmm.
And in fact, my lord, here the difference is, my lord, after the revision of pay, my salary, the grade pay ought to have been, my lord, 13,900, whereas I am being paid 13,300. That is the case. And fact, my lord, the honorable court in the earlier order, my lord, has dealt with this everything, my lord, and said that, my lord, I am under the earlier petition, they were entitled to the revised pay scale yes, from the date of the join. So far, the grade pay is concerned. Similar order is paid for in this case. Same footing. In fact, my lord, I was appointed, only thing that I was appointed an assistant coordinator, which is equivalent to the rank of assistant secretary. So if it is secretary, my lord, then I again fall in the same footing as that of the.
So show me the facts.
So, what? Page 15 is the appointment order, my lord.
Jyotismita Bora.
Jyotismita Bora. If she was appointed as an assistant coordinator, you know, in the pay scale of 12,000 to 40,000, grade pay of 5,900. This was the initial appointment. It was for a probation period of 2 years. The second paragraph of lordship will see. Thereafter, below page 16, my services were confirmed.
Okay.
So with effect from 1/8/2020. Now, in the meantime, you know, in view of the revision of pay, you know, the salaries were enhanced. And in fact, you know, earlier it was 12,000 to it was the scale was 30,000 to 1,10,000. Grade pay was given 13,300.
No, initial grade pay was 5,900.
Yes, sir, that was after the division of pay, it was enhanced. That is an admitted question, but in fact, they have also admitted. And the revised pay which was given to me is 30,000 to 1,10,000.
Where do I find that?
The document is not annexed there too, but at the same time, just paragraph 9, page 8. The petitioner expressed that the petitioner was appointed in a scale of 12 to 40,000, grade pay of 5,900 per month, and our scale is revised to 30,000 to 1,10,000, and grade pay is 13,300, which is below the pay scale of the assistant secretaries of the HOD level 1 of the secondary education department. As per revision, the pay scale is 30,000 to 1,10,000, and grade 5 is rupees 13,900. So 600 just difference of the assistant secretaries of HOD level 1 so and so.
But she was paid how much?
That is grade pay 13,300.
But it should be 13,900.
900 because in the affidavit filed by the respondent authorities, they have said that the post of assistant coordinator, assistant secretaries are the same. So that is there. So I was to be given 13,900. That is it. Now I'll just take you to the order. It was in a similar case. We have been filing representations, that was not considered. And if your lordship kindly comes to page 18, the order. It's exactly similar to my case, only thing the posts are different. But if your lordship, before that, if your lordship wants, I can just for a moment, I'll take you to the affidavit, at page 81. Before I take you to the order, page 81, that is the running page.
81.
81 is the affidavit filed by the respondent authorities. Paragraph 4. The deponent further backs the last 4 lines of paragraph 4. The deponent further backs that the petition has been working in this office as assistant coordinator in the equivalent pay scale of assistant secretary. So, the post of assistant secretary and the assistant coordinator are the same. And in fact, Page 82 again, Milord.
Hmm.
They have referred to the order of which page, Milord? They passed in WPC 992 of 2009. Middle part, the Honorable Gauhati High Court was pleased to pass an order dated so and so, whereby the Honorable High Court directed the Assam Higher Secondary Education Council to fix basic pay of the incumbent in the level of level 1 HOD. Since his date of joining as Assistant Secretary in the office of the Council, accordingly, in compliance with the said court verdict, the basic pay of the incumbent had to be refixed as per level H1 HOD since the date of joining in the Council. So in that case, they have complied with the orders also. So that order has happened finally. Now, again, they have referred to page 83, the middle part, I'm referring to the affidavit in view of the fact, they have admitted. She was appointed, that is sixth line, she was appointed as assistant coordinator under Assam State Open School of so and so in the pay band of 1200 to 40,000 and GP of 5,900. Pre-revised scale of ROP 2010. Pay scale of the petition was subsequently revised to rupees 30,000 to 1,10,000 and GP of 13,000 per month as per the rules. So now, if your lordship kindly comes to they say, there is the post are not this, otherwise the assistant coordinator and coordinator are not the same. But that has been.
Then again, in the previous paragraph, they said what?
No.
Paragraph 4?
Paragraph 4, they admit, the post of assistant coordinator and the post of assistant secretary are the same.
Then?
So, I'm otherwise, since assistant secretary, they are getting 13,900. So if that will be so, then I'm entitled to 13,000.
They themselves said that.
Yes. And I'm not being given, that is my grievance, In fact, the order is explicit. If your lordship kindly takes the order now, in viewing the admissions, I'll just take it to it's a long order. By filing in the second paragraph, page 18. By filing this petition under Article 226 of the Constitution of India, petitioner seeks a direction to the responding authorities to grant him the pay scale of 6,000 so and so as an office belonging to the level 1 directorate instead of this so and so. This is similar in my case, which is presently getting as officer of the level 2. In other words, grievance of the petitioner relates to upgradation of his pay scale from so and so to so and so.
Okay, that one I've understood.
Now,
yes.
So, since we are in the
So
same.
what do they say? They say that these posts are not equivalent.
No. They are not saying so.
Huh.
In fact, there's one statement, but that particular part, even otherwise, I am equivalent to the post of grade 1, level 1, in that of the secondary education. So, the scale has to be same. They are admitting that.
Why the scale is different other than why?
That point of time, we never know, and pursuant to the orders of this honorable court, that has been complained. I've been left out, That is why I'm before this court.
What do you say, Mr.
Yes, lordship may dispose of the same cadet, lordship pending same cadet.
Hmm.
Dispose by a small order, directing the secretary. Now I accept Assam State School Education Board from 2017. Just the thing fourth, secretary to the division 2. With a direction by the.
Prefix the pay grade.
Yes, this is about rules, about alia rules.
So assistant coordinator and assistant secretary.
Same cadet, that is true.
Class 2 junior.
Yes. Same. So, what's my disposal with the director to the secretary? Consider her case. Along with the other cases, they also have a high court order. Justice Ujjwal.
Okay. Heard Mr. R.K., learned counsel for the petitioner, and Mr. T.G. Chutia, learned standing counsel for.
Accept, now accept, Assam State School Education Board.
Assam State School Education Board.
2, 3,
Why does
and
that-
4.
Respond number 2, 3, and 4. Miss D. Mushahari for respond number 1.
And also 5, 6, 7 also.
5,
2,
6,
3,
7
4,
also.
5.
You are there for, right? Mr. Chutia, you are for 5, 6, 7 also.
Yes, not 7, 2 to 6,
2 to 6, huh?
Yes.
1 for D. Mushahari. and 2
But 7 also, finance committee.
Seven is finance
Yes,
committee.
It is under them.
Education council 7.
Yes.
By this petition, filed under section 1, filed under article 1, 226 of the Constitution of India. The petitioner has prayed for for raising the, what do you say, the raising the grade pay
Great pay.
from rupees 13,300
Yes, my lord.
to rupees 13,900,
900.
corresponding to the pay scale of level 1,
Yes.
head of the departments of the government of Assam. Full stop. The petitioner has challenged in the said petition the impugn action on the part of the respondents. It has challenged the action on the part of the respondents in depriving the petitioner of the legitimate pay grade. It is the case of the petitioner that she was appointed to the post of assistant coordinator under the Assam State Open School of the Assam Higher Secondary Education Council in the pay scale of rupees 12,000 to 40,000 and grade pay of rupees 5,900 by order dated 12/9/2016. Full stop. The petitioner was placed on probation for a period of 2 years by the said order. Full stop. Subsequently, on 29/8/2020, the services of the petitioner was confirmed to the post of assistant coordinator against the sanctioned post
Updated by much.
upgraded, sanctioned post with effect from 1/8/2020. However, later on, the pay scale was revised to 30,000 to 11,000
So 1,10,000.
or 30,000 to 1,10,000. And the grade pay was also revised to rupees 13,300. I started the line with however. No, give me up. Later on it was revised. However, it is the case of the petitioner that her post is equivalent to the post of assistant secretary of HOD level 1 of secondary education department. And the assistant secretaries. And the pay scale is revised to rupees. You don't say rupees, right? Pay scale was revised to 30,000 to 1,10,000. And grade pay was also revised to rupees 13,900. But in case of the petitioner, the grade scale was revised only to rupees 13,300. Agreed with the fixation of the grade pay below that of assistant secretaries of HOD level 1 of secondary education department. The petitioner submitted representations last being 11/7/2023, but the same was not given any hit to the HWD by the department council. Mr. R. D, learned counsel for the petitioner submits that the post of assistant secretary and the post of assistant coordinator are in the same grade, and both the posts should carry the same grade pay. However, a distinction is made for regions best known to the respondent authorities. Hereby referring to the affidavit filed by respondents have placed that the respondents have also admitted that petitioner has been working in the office of the Education Department as assistant coordinator in the equivalent pay scale of the assistant secretary cadre post since 14/9/2016. Also, Mr. R. D has also placed an order of this High Court dated 16/8/2016 by which this Honorable High Court has given relief in a similar case in writ petition number 992 of 2009. Mr. T.C. Chutia, learned counsel for respondent number 227, also fairly submits that in the regulations of Assam Higher Secondary Education Council, within bracket condition of service of employees regulations 2021, conditions of service of employees regulations 2021. In chapter 2, which provides for the class and cadre of the service, both the post of assistant secretary and assistant coordinator are placed in same class 2 junior cadres. In same class 2 junior. No other facts are required to be mentioned here about revising scale and all those not required.
That has been dealt with in the order of the Honorable Court.
In such circumstances, in view of what has been stated above, there is merit in the contention on behalf of the petitioner. And as such, it is directed that the petitioner would be entitled to the revised pay grade of rupees 13,900 with effect from date of joining.
Yes, ma'am.
With effect from date of joining or confirmation.
Date of joining.
With effect from date of joining in the post of assistant coordinator.
That is 2016.
That is,
Yes, ma'am. 12/9/2016. That is what.
that is
12.
from the date of
It's a one.
12/9/2016.
Yes, ma'am.
Also, say consequential benefits shall be released to the petitioner within a reach. Oh, yes. Consequential, further, consequential benefits shall be released to the petitioner within a reasonable period of time from the date of the, within a reasonable period of time from the date of this order. Writ petition is allowed, no cost.
Obliged, ma'am.
That's Mr. Mahanta.
Respondent, I've already filed my application. Wait, please, your next.
Yes, yes.
This petition challenges the illegal usurpation of the
Reading
quota.
complete.
Without
Hmm.
And she's challenging my
appointment.
advertisement is of the town.
Hmm.
Appointment of this town.
Can be disposed of.
Not appointed, okay, but then she is also not appointed.
No,
No, actually what happened? The both of them and they are appearing in the minor examination conducted by the PSC minor. And now she got selected and then now minor the petitioner stating that minor the certificate issued by the produced by the respondent number 4 regarding the EWS. That is minor not genuine.
Not genuine.
Sorry, that is a PWBD, the person with the
benchmark disability,
so
30%.
Yours.
but that is the issue, my lord. So that issue, my lord, we have nothing to say because we just certificate produced by them. Accordingly, we allow him to sit in the examination. He got passed. So now claim is, my lord, that is not genuine. Whether it is a my lord, is genuine or not, that my lord, then it will be it has life. Otherwise, my lord, she says that probably
Not appointed.
yes, government has a power to the exam.
They state the appointment. That's something. And saying it's less than 40. Benchmark.
And you are not entitled to sit in the examination at all.
They have scrutinized, they accept in my certificate, it's more than 50. So according to me, I am qualified. According to them, qualified because it's less than 40. But my certificate shows that it's more than 40.
But then you are not appointed.
Not-
And neither you will be appointed.
That is happening to the APS.
No, this is not appointed by the government. We are just conducting the examination. The examination and submit the recommendation.
You have conducted examination and she passed.
She passed, I will recommend the name. We
For
recommend the
appointment?
name to the government and government not yet appointed.
Not yet.
No.
And you are a failed candidate.
Lordship, ladyship, I was not selected because another,
You did not appear in the exams.
I did.
Acha. And you are not selected. And you say that she should not have appeared in the.
No, not that. She was not eligible, meaning
On
they
that
were-
quota.
in terms of, because earlier in another examination where both the petitioner and the respondent poll had appeared, the Gauhati Medical College had constituted a board, a medical board in terms of the rules.
This is what examination?
This was for financial management officer,
Acha.
junior grade 2 under Assam House Urban Financial Service, Department of Housing and Urban Affairs.
Now, what do you say? Is it alive or not? Now that she is not appointed, you have challenged her appointment, her selection. Now whether, what? Is it alive? Do you want to still proceed?
Can be disposed of in terms.
On what ground? That she is not appointed, that she is not appointed. You take proper instruction or what?
Yes, like, I have not yet been instructed to that effect. So,
What do you say, Mr. Mahanta?
My lord,
You're an
we-
expert in service.
no, my lord, here, probably, my lord, no. But if he want to prove that, my lord, that certificate issued by the authority is not genuine, then there is a lie.
Mm.
Because that has to be decided,
Certificate showing that she has 50% and above.
my lord.
Uh-huh.
Here happening, the
Acha, then, acha.
So now that is up to the government whether they will accept it or not. Because when after recommendation, they have a power to re-scrutinize the certificate. So now who will say that it is not genuine, or he will say, my lord, who will decide? Because the department who issued it was not the party here. That issued by the health department, Joint Director of Health Service, Gauhati to Laka. It will not be for the issue.
So who will consult? You said that there was a committee for.
There sometimes my court, my lord, they refer to the committee. But in the case of another recruitment process, my lord, not in this.
You take proper instruction then. Whether to still challenge her selection or not. But you may still be appointed if the government meets.
There is an interim.
There is an interim order, it is the subject to decision.
Subject to outcomes.
Sub-
That is always there. Otherwise, posts are filled up over.
That means
No, that can come.
Okay, you bring, both of you bring instruction of Mr. Chutia or who's that? Miss Fukon. That's one number one, housing and urban, who appears? Okay. Third is each of you, learned counsel for the petitioner, and Miss J. Kumar, learned counsel, and Mr. T.J. Mohanta,
2 and 3.
learned counsel for, learned standing, what?
My
Learned,
lord, respond number 2 and 3.
learned counsel for respond number 2 and 3, and Miss J. Kumar, learned counsel for respond number 4. Ms. J. Kumar, learned counsel for respond number 4 submits that the petitioner has challenged the selection of respondent number 4 in the instant writ petition. But the respondent number 4 has not been, although has been selected, but has not been appointed yet. And as such, she submits that you cannot say that it has become infectious or so. You still have, when you have a stay of, she has a stay also. So, yes, yet, full stop. In view of the said submission, Ms. B. Chaudhary, learned counsel for the petitioner, as well as it is directed to the learned standing counsel for Housing and Urban Affairs Department to bring, to place instructions as regard to the fact, as regards to the fact that whether the post for which the selection process was conducted were all filled up on the next date. But then still it is outcome of this writ petition, even if it is filled up. they have to-
Normally, my lord, nowadays, my lord, 50 posts advertised, always 50 posts minus recommended.
Mm.
So there cannot be a wait list now. So probably still, my lord, that is that. Because normally, recommended, my lord, recommendation always made as per the advertisement. Suppose 50 posts advertised, after recommendation, as per FRDF.
But then here there is an order for outcome. So she-
Yes, if there is an order that he can, yes, probably on acting on that, my lord, they may not be appointed.
So let them bring the
Let's just.
Is this matter after 2 weeks on a date to be fixed by the registry.
Much obliged.
Please, Your Lordship. Lordship, may kindly peruse the last order 24/11/2025 to the present case.
24/11,
2025, Lordship. Lordship, the petitioner was an assistant teacher, was working in,
otherwise pleadings are complete.
no, Lordship, the secondary education has to bring in. No, Lordship, elementary education was made a party, then they have stated that
secondary education should be included, and accordingly we have included secondary.
Particularly, school has amalgamated with secondary department.
So elementary and secondary were amalgamated in that.
So later on, as the secondary education was being included as a party, after elementary education had submitted that they are the necessary party.
Mm.
And for the last 3 occasions, secondary education have been taking time to bring instructions.
Because, when the school was amalgamated in 2017, the petitioner, there is a gap period where the petitioner was not working there. So when the amalgamation was made, most probably also because he was not working, her name was not there in the amalgamation order. So she was not there. So that is why she has not been able to join in the state school. So the clarification has to come from the elementary department, Your Lordship, as to why she was not there, not working, as to whether we can, whether her name can be in the amalgamation order, because she was not working.
And earlier she was working in the elementary.
Yes, Your Lordship. She was appointed in the ME school, Your Lordship. Because only.
So they have to bring the instruction
Your
why her
Lordship.
name was not.
Yes, yes.
Lordship. But elementary has been party from the very beginning.
So elementary has filed their affidavit.
No,
My
Lord.
lord, instruction is awaited, my lord. Today morning, I have talked with my lord, and the department has called for the headmaster, again school, my lord, to bring some document, my lord. All hearing is conducted on 27/3/2026, my lord. So we, my lord. So, I pay some after 27, my lord. Or immediately after vacation, my lord, in the meantime.
Okay, heard Mr.
A. Borwa.
A. Borua, learned counsel appearing for the petitioner, and Ms. B. Talukdar, learned
Start with order, my lord,
Mr.
for
B. Talukdar for
respondent number 1,
learned standing counsel and.
elementary education.
You are elementary, right,
My-
Talukdar?
My lord,
For elementary education? That is respondent number
1, 3, 4, 5, and 6.
1, 3, 4, 5, and 6. Huh? And Ms. D. Mushahari, learned counsel for secondary education. Respondent number 8. That is respondent number 8.
Subsequent.
The case of the petitioner is that her name is not included. What? No.
No, after amalgamation, she was not allowed to join the school, and
She has not been allowed to join in the school after it was amalgamated with the secondary. A secondary, what do you say? Secondary?
the name of the new school is Lordship Gauhati Night High School.
Acha, with the secondary, what do you say? Secondary school? No. Secondary department? No.
Secondary, high secondary school, Your Lordship.
Amalgamated with the higher secondary school. But 24 order, you see, she was, she had some psychiatric problem and so she was absent. So
Lordship.
she is split and she was superannuated on attainment of the age.
34, 2025.
She had retired.
Lordship, now we are only praying for the pension and pensionary benefits.
That period has to be regularized, Your Lordship. For regularization, a proposal has to come from the elementary department.
Read it again. The petitioner also states that she was absent prior to the amalgamation in her school. And that now she is superannuated from her service. But for pensionary benefits, her period of absence has to be regularized. For which the learned counsel for both the secondary education and elementary education seek some time to bring the instructions.
Worship.
Lordship, we see the prayer, your lordship. Was prayer,
As for prayer, my lord, the matter become important. Regarding pension, my lord, the
Worship,
file have press petition, my lord.
Number two, Lordship, that's the action treated as a duty of
That's, allow for the petition.
These prayers cannot be granted in this proceeding. You have asked for two prayers.
Worship.
One is that allow her to continue her service till date
Worship.
for her retirement.
In the meantime, she had retired.
So in the meantime, she has retired. Your
Worship,
second
but
prayer is
second prayer-
also absent period may not be treated for pensionary benefits. You yourself foregoing it.
If petition allowed, my lord, then this.
Huh. You're yourself foregoing that absent period may not be treated as on duty.
No, it may be treated as on duty.
Why it may not be treated? Why it may not be treated? Okay.
So Lordship, this is still alive. Let them bring in instruction.
No, you have to make out a case here. And you have not rejoined.
I went to the college to school in 2018 itself to rejoin. But in that period, there was a contempt case going on for the earlier paid arrears salary. And the department had, school and the department had told me that whenever the contempt case is over, you then approach. Then again, we have approached in 2024 that the contempt case is over. Now the honorable court has directed to pay the arrears salary. So let me continue. But then they have not given me any answer and not let me join.
So this petition will not, it doesn't survive. You see your second prayer, why absent period till date of joining may not be treated. So you have not at all joined. So what survives? This petition does not survive. And in the interim also may not be allowed to join and continue her service till her retirement. Now that you are retired, you file a fresh petition for pensionary benefits. Seeking fresh prayers. Otherwise, the prayers do not survive. He is rightly pointed out. You file a fresh petition. I'll dismiss it, I'll close it, or you will withdraw. I'll close it. Not the earlier one. Okay, third, Mr. What?
A Borua.
A Borua, learned counsel for the petitioner, and Mr. B. By this petition, say article,
I may be allowed to
withdraw.
file a fresh.
Mr. What?
A Borua.
A. Borua, learned counsel, submits that he has instructions to withdraw the matter and with the liberty to file a fresh writ petition with new cause of action. Prayer is allowed, matter is closed as written.
Alia.
Dispose of the matter, my lord. I thought about 15.
Huh.
That's it, my lord. My lord, lordship, a correction will be given as now for an essay, not a township. Assam State School Education Board Division 2 Secretary.
The direction has to be to them.
Yes. Would have
Item 15. Acha, direction was to be given to
Secretary, my lord, Division 2, Assam State School Education.
Division 2.
Division 2. Assam State School Education Board. Now it's changed nomenclature. Now it's
So now it is.
Alia question, it was Assam Higher Secondary Education Township. Now it is known as Assam State School Education Board.
Earlier it was Assam
Higher Secondary Education Township.
Higher Secondary
Education Township.
Education Council, now it is
And now it is my lord Assam State School Education Board.
Assam State.
School Education Board. Division 2, this matter relates to Division 2. One is Seba, my lord, earlier Seba, and there is a council. That is the point.
Division 2.
Yeah.
Direction will go to now state level education, right?
Yes, sir. Assam State.
That I will correct. 19. 19 is before me. Yes, 19, yes, Council.
Yes, Lordship. With legal options, they have not filed any affidavit, Lordship.
It's on 17, on 12th of May. Appeal pending.
Appeal. I have no idea about this thing.
Okay, you write it in the affidavit. Whatever you have to say. Yes, Miss, you are for BTC?
Yes. BTC. No, BTC is not person. BTC is not a party in this case.
This is 19. What is the different one? Okay, so no one has filed affidavits.
No, Lordship.
The Chief Secretary, Government Advocate, not required, I think. Then the Department of Education, I'm there. You are there. And also secondary education, Mushami is there. Oh, same. Achha, right? Third Miss.
And they.
And the Learned Counsel for the petitioner. And Miss Terampi for respondent number 2 and 3. 2 and 3. 4, finance. You're 4. Learned Miss RM Borua, Learned Counsel for respondent number 4. And Government Advocate K. Fukon is now there. Okay. It is stated by the petitioner, by the Learned Counsel for the petitioner, that none of the respondents had filed their affidavits.
On the last occasions, they taken the time for filing affidavit, Lordship.
Bring instructions, I think. Right? Which would be necessary for adjudication of the instant case. As such, direction is given to all the respondents to file their affidavit before the next date fixed. Let's just matter of when do you want?
After 3 weeks.
Let's just matter on 29th of April. Okay? You file your affidavits.
Okay. The other side is yet to file the affidavit.
Who is appearing?
2 weeks.
Yes, sir. You're for respondent number 3, right? 3 and 4. 3 and 4. Respondent number 1 and 2. What about 5? 5 also you are appearing, I think. Oh no, there's a private respondent. So you have taken notice. You have
Yes.
taken steps.
Yes, Lordship.
What about service?
It is completely Lordship.
Completed. Okay. Third Miss
P. Bora.
P. Bora, Learned Counsel for the petition. And Miss G.R. Mohiliari for respondent number 3. D. Mushahari for respondent number 1 and 2. And who is for? Achha, this Mohiliari is for respondent number 3 and 4, huh? The counsels representing the respondents seek some time to file their affidavit. Prayer is allowed. List this matter on.
Lordship, if I may, I'm on the date before vacation.
List this matter on 8th of April.
Deputy Officer.
Yes, Ms. Mohiliari, try to file it before 8th of April.
I think in this case also, when the government has not filed affidavit,
Yes, government.
PhD department. That pertains to promotion.
Okay, third, Mr. S. Hawk, learned counsel for the
Appearing on behalf of SO, A. Rahman.
A. Ahmed, learned
A.
counsel.
Rahman.
A. Rahman, learned counsel for the petitioner. And who is appearing? Health? Health, no one is there? PHE? Or it is PHE or no? Huh?
PhD.
PHE? Yes, Mr. Hawk. So PHE, who is appearing? Bring some counsel from the PHE. Yes, Mr. Chutia, who appears for PHE?
And by the, I think, well, he is from irrigation, for irrigation. PhD and Parangon, I think.
A. Bothapur. Has she come to the court?
I have not seen that. I have not seen that.
Call A. Bothapur, then of and you can pass out. Okay. After some time. After some time. 23 is more. Gotcha.
Saxon is limited minus, so I pay for some accommodation money. It come up after immediately after due vacation money.
Mr. B. Talukdar.
Standing council elementary.
Okay, Mr. B. Standing Council Elementary Education. Prays for some time in the instant matter. Prayer is allowed. Let's this matter on 24th of April,
My God.
2026, on which date he submits that he will place the instructions.
Congratulations.
May I please also. My lord, in this case, I have received affidavit in opposition today itself.
Ah.
So, my lord, I have to file rejoinder and that will be posted after the direction.
You are Mr.
K.U. Ahmed.
A.U. Ahmed, learned counsel for the petitioner, submits that he has received a copy of the affidavit in opposition today and he needs some time to file the reply to the same. Prayer is allowed. Place this matter on
27th of April.
27th of April.
Obliged.
Acha, Ms. Moore, I was just thinking about your matter because here there is a stay order. There is an order that your appointment is subject to the outcome. So they will definitely appoint.
But Lordship, I have talked with the counsel who has engaged me. So he said the respondent number 4 was called to come for a re-examination. So after re-examination, they found he's disabled less than 40%. So they have not appointed. So matter is more or less becoming. That's what I came to know.
Acha, she was called for re-examination
Re-examination.
and she appeared in the examination.
Re-examination, and they found that it's less than 40%, and 40%
Her
is
marks is less than 40.
not the marks, disability benchmark should be more than 40%. So they found that it's less than 40%. So
But that exercise should have been done before the examination.
and the certificate, they have scrutinized it and they have said it's genuine. Because in the certificate which has been issued by the Golaghat Medical College, it's written more than 50%. That's it.
Acha, she was not found eligible.
She was found eligible by the scrutiny committee. So thereafter, she appeared for the exam and she was selected by the Assam Public Service Commission. Mr. Ghonta has appeared. Thereafter, this petitioner has come and challenged, saying that her certificate is not
Your
genuine.
certificate.
My certificate is not genuine, and her percentage is less than 40%. It should be more than 40%. Right? It's around 30%. So later on, they have called me as per the instruction and examined me and found that it's less than 40%. So that is
Call the petitioner.
no, call the respondent number 4. That is me.
Call respondent number 4.
Yes, ma'am.
And it was found that it was less than 40%.
Yes, ma'am. So,
As stated by the petitioner.
yes, stated by the petitioner.
Oh, acha, acha.
So it's next time it will be.
Okay. Then you bring this.
Next.
May I please your lordship?
Yes.
In this matter, the petitioner, pursuant to orders of this honorable court lordship, both the petitioners participated in the selection process. However, result has not yet been declared, lordship. That is the status now.
So here they are supposed to file affidavit, your lordship, as per last order dated 15/10/25. Should that may be filed or instructions may be brought, your lordship, on the mail?
Yes, counter affidavit, respond number.
I didn't get the instructions are.
Heard, Mr.
And KG second.
KJ Sakia, learned counsel for the petitioner, and Miss
P. Sharma,
P. Sharma, learned counsel representing
123,
TJ Mohanty, senior counsel for respond number APSC
120.
1, 2, and 3. Miss P. Sharma, learned counsel, submits that she requires some further time to file the counter affidavit in the instant case and have instant case. Prayer is allowed. List this matter when in. List this matter on 27th of April. By which date?
First date on May,
On 5th of May, by which date the learned counsel will place, will file the affidavit without fee.
much of
27 also saying, huh? 28.
May I proceed?
Hmm.
The petitioner has retired, my lord, on 31/12/2023, and his pension has not been settled.
Has not been settled.
Yes, my lord.
What about respondents?
Respondent PhD department, my lord, they have not responded yet.
PhD department, earlier also there was no counsel. What about, are you appearing for PhD, Miss Counsel? You are appearing for?
Accountant general.
Huh?
Accountant general.
Accountant general. Respondent. Now PhD counsel is not there.
Yes.
So accountant general is fine the affidavit.
Yes, they're fine.
PhD is required to file.
Yes, they may file or may not file, my lord, up to them, but the Malala can bring.
You're for the PhD. Two matters were kept on board in because of your absence. Here you are like, you file your affidavit or you need not?
We need some time to file it.
Mr.
I got it.
I brought up a learned counsel for PhD department. Prays that he may be allowed some time to file the affidavit. Prayer is allowed. It is noticed that respondent number 5 has filed the affidavit and the same is on record. List this matter on. When you mobile can you file?
Sir, do you any date, my lord?
List this matter on 28th of April on the reopening or 22nd of April. Acha, wait, PhD department, there are 2 other matters which is kept pending. Acha. Item number? 22.
20.
Did you file affidavit or it will proceed like this?
My lord, here also some time.
Yes, heard Mr. S. Hawk, learned counsel for the petitioner. Mr. I. Botapo, learned counsel for PhD department, please, that he may be allowed some time to file the affidavit. In the instant case, prayer is allowed. This matter on 27th of April. Same is in respect of 28 also. No, 23.
23.
23 also same. Oh, you file your affidavit.
Both their matter may be kept together.
What you call that, the learned counsel submits that, that the analog, that the other repetition being repetition number 3194, 322, 3194 of 2025 is a connected matter and the same may be listed together along with the present repetition.
Resolution number 3137.
That is petition number 3137 of 25.
Right.
Prayer is allowed, list accordingly.
Public.
May I plead your lordship?
Yes.
Lordship, the respondents were supposed to file an affidavit.
APDCL.
Yes, affidavit.
Mr. KP Pathak appears for, or who? Who appears for APDCL? Mr. B Das written on the last occasion. Who has already received instructions on the last date, December 25.
Yes.
He should have filed the affidavit, but then he has not filed. Contact Mr. B Das. Who's B Das? Heard Miss?
D.R. Bongsheri. D.R. Bongsheri.
DR?
D.R. Bongsheri.
DR Bongshel,
D.
learned counsel for the petitioner. On the last occasion, the standing counsel, the APDCL, had submitted that he had his instructions and that he would file his affidavit. But when the matter is taken up today, the learned standing counsel APDCL is not present. Neither any affidavit is filed. Matter is fixed. Matter is fixed on 6th of April, 2026 for further orders.
Lordship, much obliged, Lordship. Yes, Sir, Lordship. Lordship, this matter may be adjourned from today and fixed on Friday, Lordship. Because the arguing counsel, due to some medical emergency, could not appear today. And there is an urgency because AIT examination has already been started. And,
You want the matter to be taken up on this Friday?
yes, sir.
Reaction to
Yes, Sir, Lordship.
Miss
A. Hussain.
A. Hussain, learned counsel for the petitioner, makes a prayer that the instant matter may be taken up on 27th, right?
Yes, sir.
27th of this month. Prayer is allowed, list accordingly. On Friday. I'll just come back in 5-10 minutes, sir.
GMC, I have received my instruction. It will come after vacation, re-vacation, I'll file my affidavit.
You have received your instruction.
Yes, I have received the instruction on behalf of GMC.
GMC.
Yeah, I am appearing for GMC, GDT and Housing, Department of Housing and Urban Affairs.
Housing and Urban Affairs.
It's regarding the pension, my lord, from July 2025, my lord. More than 2,000 petitioners are there. They are not getting their pension, my lord. So it's becoming very difficult for them to survive, my lord.
Why depriving of their pension?
Regularly they were getting,
Let
and
me file
suddenly
my affidavit, my turn.
fixed date may be given, my lord.
Your response number 2, 3.
I am appearing for 2, 3, 5 and 6. 1, 2, 5 and 6.
Heard Miss J.M. Paul, learned counsel for the petitioner, Mr. S. Bora, learned standing counsel for Department of Housing and Urban Affairs. That is respondent number 1, 2, 5 and 6. Submits that he has the instructions from the said department and he needs some time to incorporate the same by way of an affidavit.
I have received instruction only from GMC.
Received instructions from GMC. And he prays that he may be allowed some time to file an affidavit incorporating the same. Prayer is allowed. Mr. Chutia, you are for?
Let's go to the 4.
You have filed affidavit?
No.
You will file or you will not? Mr. T.C. Chutia, learned counsel for respond number 4. Also prays for some time to file the affidavit. Prayers are allowed. List this matter on
Let it on 23rd April.
23rd of April. 26.
Okay.
Yeah, of course. 32 kilo, all times. 33 BTC.
Lordship, Instruction is awaited, Lordship, so some time may be granted for getting the same Lordship. After you, Lordship.
Miss Mishari was also supposed to.
Well, notice was issued on 1912.
Yes, 1912. Miss Chaudhary, M. Chaudhary, Learned Counsel for WTC. That is respondent number 1 and 2, both. Where respondent number 1 and 2 prays for some time to file the affidavit in opposition. Prayer is allowed. List this matter on.
After 20.
List this matter on 29th of April.
Diplomat.
So it can be taken up after some time.
It can be taken up for disposal or what?
Lordship, we have received our instructions, Your Lordship, it's regarding pension, Your Lordship. The provision pension has been given, Your Lordship, however, we are unable to give the regular pension because the audit report is awaiting, is awaited, Your Lordship, from the petitioner. Because nowadays it is uploaded in the Pitagata portal, Your Lordship, the audit report has to be given to the
That has to be given by the petitioner.
petitioner, Your Lordship.
Lordship, this means I'm not in this case, Lordship. I'm not adversely matter.
Okay, something.
Lordship, this item as well, Lordship. Customs the export will appear in this matter, Lordship. These are legs.
Right, Lordship. Lordship, in this case, Lordship, I filed on this case, Lordship, there is some clerical mistake, Lordship. Kindly see page 11, Lordship.
Yeah. Miscase is for what?
Correction, Lordship.
Correction of order.
Order, Lordship. That is, it is as per the Lordship, office note, Lordship. That's a Lordship. That it should be respondent number 7, Lordship. It is mentioned at respondent number 6, Lordship.
In the order of this High Court,
Yes, Lordship.
passed by
Asked by Honorable Justice. This is Lordship, Honorable Justice. Sanjay Rao Mehdi, Lordship.
Justice S.K. Mehdi.
Yes, Lordship.
Let it go before the same bench.
Well, Lordship, actually, Lordship, this respondent number 6 or 7, not, he is no more in this case, Lordship.
Not in this case.
No, in this case, Lordship, no more in this, in the post, Lordship, as the official liquidator, Lordship. The Lordship, one case, Lordship, item number 2, today's list. As per.
No, what correction you want?
Correction is, Lordship, only respondent number 6, Lordship.
Which page what?
Lordship, kindly see page number 11, Lordship.
Of the IA?
I, Lordship. I have annexed the order, Lordship. Last, last,
Yes.
Lordship, it is accordingly Kuldeep Burma, the liquidator of HPC, so imputed respondent number 6.
Okay.
WPC number 803.
Hmm.
Although, Lordship, this miscase filed for impleading in miscase number, Lordship, 1705 of 2013, Lordship. But it is wrongly.
Acha, writ petition number is wrongly given, wrongly written. Writ petition number
Lordship, and respondent number 7. It should be.
and respondent number 7.
It should be respondent number 7, Lordship, as per office note, Lordship. With that matter, Lordship. The next date, Lordship, if it is corrected, I am will be, Lordship, the stock of this respondent, Lordship, respondent 7. Because
Otherwise, respondent number 6 is someone else.
yes.
And this Kuldeep Verma has to be implemented as respondent number 7.
7.
And in writ petition not 803.
No, it is 1705.
It is,
1705.
but 803 writ is there.
Yes, Lordship. There are 2 writs, Lordship, on the same. One filed by me, Lordship, the workman, another by the HPCL. HPCL is.
You go before the appropriate court,
Lordship.
same court. We'll make the corrections, right?
Only keep this correction. Respondent number 7, Lordship, as per office note, Lordship.
Office note, what is office note?
Kindly see, Lordship, the office note of this case, Lordship.
Office note.
Yes, Lordship. Please mention, Lordship.
Okay. Office note also says that it has to be respond number 7.
7, Lordship.
But go before the same court,
Lordship.
right? Or it can be done by this court. But then go
Clerical
before the
mis-
same court, he has heard, he has seen the matter.
Clerical mistake is okay, Lordship.
Okay, heard, Mr.
B. Malaka.
B. Malakar, learned counsel for the, you don't have any objection, right? Including the number is wrong. B. Malakar, learned counsel for the applicant. And Miss
P. Sakya,
P. Saikya, learned counsel for the respondent.
respondent number 6.
Respondent number 6. By this application, the petitioner has prayed for correction in the order dated 8/6/2023.
Lordship.
Full stop. The learned counsel submits that in the said order, Shri Kuldeep Verma, liquidator of Hindustan Paper Corporation, was allowed to be impleaded as a party respondent,
Number 7.
but while ordering, he was directed to be impleaded as respondent number 6. Whereas in the array of respondents, he should be impleaded as respondent number 7. And further, it is also stated by the petitioner's counsel that the said liquidator has to be arrayed as respondent number 7 in another writ petition, that is WPC number
1705 of 2000.
1705 of,
No, another repetition number that is 803 of 2013, filed by the
803 of 2013 only.
only Lordship. Now, my repetition is 170513.
You want him to be impleaded as 7 in another writ.
No. Kindly see page number 9, Lordship.
You want correction only in respect of respondent number 7
Respondent 7.
and nothing else.
Nothing.
Got it. Further pakati. As such, the said Kuldeep Verma, liquidator of Hindustan Paper Corporation, be impleaded as respondent number 7 and not as respondent number 6 in writ petition number 803 of 2013.
Lordship, actually, Lordship, this is Lordship 1705 of 2013.
This is what I'm saying. You want
Yes, Lordship. My prayer is there for that, Lordship. Kindly my prayer, Lordship. Page 7, my prayer, Lordship. And page 8, Lordship, order.
this is what I was dictating and you
Lordship,
confused it.
sorry.
And here there is no prayer of respondent number 7.
7.
This is only in the office note.
Office note, Lordship.
You wanted correction only in respect of writ petition number.
No, Lordship, respondent number 7, Lordship, office note said, what happened, Lordship, in this case? There are 2 miscases filed, Lordship, simultaneously, Lordship. Now, one is, Lordship, for making party, Lordship, industrial department as respondent 6. Simultaneously, another petition filed, Lordship, respondent 6, Kuldeep Verma, Lordship. One allowed, Lordship, earlier, later on allowed, Lordship.
I don't want this history. Now you tell me that what you want.
Lordship, only respondent number 7, Lordship.
But respondent number 7, that was not in your prayer.
Lordship.
It is only in the office note.
Office note, Lordship. Lordship.
Just, further, further in the counsel for the petitioners submits that the impleadment of respondent number 7 is required to be made in writ petition number 1705
Lordship.
of 2013.
Lordship.
And the writ petition number reflected in the order dated 8/6/2023 is incorrect. And the same should be 1705 of 2013. As such, it is directed that, it is directed that Shri Kuldeep Verma, liquidator of Hindustan Paper Corporation, be implemented as respondent number 7 in writ petition number 1705 of 2013. Registry to insert, newly insert the said liquidator as respondent number 7 in array of parties in writ petition number 1705 of 2013. This order is read, this order should be read along with the order dated 8/6/2023. I is disposed of.
All right, Lordship.
Acha.
Lordship, hearing this matter, Lordship, the records were placed to me, Lordship, it was submitted to me by the department. And the records are also essential for determination of this matter, Lordship, this series matter, Lordship. But Lordship, today, Lordship, I could not place out these records in my chamber, Lordship. So I am paying for some time so that I can relocate and Lordship place it before the Lordship. Otherwise, Lordship, but we'll have to trace it out, Lordship. Otherwise, I need
Acha,
some.
you need to file affidavit or not?
No, I have already filed in all the
Or
matters.
you have filed it?
Just the
but
records, Lordship.
Records.
Yes, Lordship. So I'm paying it to be listed after 2 weeks, Lordship.
No, Lordship, next week, Lordship.
Okay. As paid for by Mr. D. Pomanyu. Oh, no, no, as paid for. Mr. D. Pomanyu, learned standing counsel appearing for Health Department, submits that he requires some time to locate the records and place it before this court for proper adjudication of the instant matter. Prayer is allowed. List this matter again on
Monday, Lordship, next Monday.
List this matter on 21st of April.
Lordship, before vacation, Lordship.
List this matter on 9th of April.
I do.
9th is holiday, Lordship.
Oh, 9th is actually
8, Lordship.
8th of April.
Oh, nice.
Yes, Mr. Butterford.
Lordship, this matter relates to pension. There was a direction by this honorable court, Your Lordship, to pay the family pension, Your Lordship. Provisional pension, Your Lordship.
Provisional pension has been given, Your Honor. It was given on 23rd of this month. Your Honor. Provisional pension given. Your Honor.
So prayer allowed.
No, Your Lordship, so far as that part is allowed, the rest of the pensionary benefits, etc. are concerned.
Lordship, I may be allowed to file affidavit
That
because there is some irregularities have been found, Your Lordship, for which the audit report has been not cleared from the particular.
Your Lordship may record that provisional pension has been.
Heard Mr. S. Butterford, learned counsel for the petitioner, and Ms. D. Mushahari for the standing counsel for secondary education. No, you are appearing for secondary education.
So second,
Secondary education. By this petition, the petitioner has prayed for a direction to the respondent authorities to pay the pension and arrear pension as well as other retirement benefits to the petitioner against the service rendered by her. Full stop. When the matter is called up today, the learned counsel for the education, secondary education, submits that the provisional pension has been granted to the petitioner by order dated
23/3/2026.
23/3/2026. However, she submits that in respect of other prayers for allowing what?
Final pension, Your Worship.
Uh-huh.
Final pension and.
For allowing final pension.
Final pension.
She submits that the authority requires the audit report from the petitioner concerned, and the process is on. And as such, she submits that she would like to file an affidavit bringing in report the said facts. Where is allowed? List this matter on when?
After 2 weeks. Your Lord.
List this matter on 29th of April.
That Your Worship, audit report is not required to be submitted by me.
She said that by you.
No, audit report.
So here it is stated that there has been irregularities have been found due to which audit clearance report was not issued. Audit clearance report was not issued.
Achha.
It has to.
No, no, from the petitioner, for which they have to obtain the audit report.
Audit clearance report.
Audit clearance report. Okay. Another matter was there, Mr. Bottom.
Lordship. This, in fact, Your Lordship, this matter. This matter, Your Lordship, I have, Your Lordship, challenged the proceeding initiated against me, Your Lordship.
Pleadings are complete.
Pleadings
Oh, we
complete,
have
Your
filed
Lordship,
it.
may take up for Your Lordship final consideration.
Yes.
It is what has happened, Your Lordship, the petitioner, Your Lordship, he was working in the Directorate of Tea Tribes and Adivasi Welfare, Assam. Now, presently he is holding the post of Superintendent, Your Lordship, on being promoted to the said post, Your Lordship, on 7/12/2020. Now, while he is discharging his duty, Your Lordship, one in the particular the office, Your Lordship, there were around 97 number of smartphones were there. In the said smartphones were part of the smartphones, Your Lordship, who were brought in to distribute among the Adivasi community people, Your Lordship. That 97 numbers of smartphones were, Your Lordship, got missing, Your Lordship. And when that got missing, Your Lordship will kindly come to page 32. An inquiry was conducted, Your Lordship. Page 32, Your Lordship, audit inquiry. Then submission of the inquiry report. Inquiry report is page 34, Your Lordship. Now, it says, Your Lordship, my statement has been recorded. And then, Your Lordship, there is a conclusion. After going through all these statements, it has come to my knowledge that without breaking the lock and key, the smartphones are missing. In the inquiry, it reveals that Sri Anil Kumar Deori, superintendent, was the custodian of the store. Therefore, he is solely responsible for missing of smartphones, etc. Now, based on this, an FIR was lost, Your Lordship. FIR, Your Lordship, will get it at page 38. It has a reference to the audit report, Your Lordship. And Your Lordship, then last part, in view of above, I would like to request to register a first information report regarding 97 number of smartphones from the 3rd floor of so-and-so director. This, then, Your Lordship, it was issued and a show cause was issued to me, not under Rule 9 of the Assam Discipline and Appeal Rules, Your Lordship, normal show cause. And I have replied to that. And then Your Lordship will kindly come to page 70. Page 70 is the order. Your Lordship may kindly note that date of the order, 19 February 2025. That is, Your Lordship, date of suspension, Your Lordship. I was suspended on that, Your Lordship. Now, then Your Lordship, search sheet, Your Lordship will get it at page 71. Search sheet was submitted by but Your Lordship, not against me. During investigation, they have found that these 97 numbers of the smartphones were Your Lordship, stolen by a casual employee of the department, Your Lordship. And that is, out of these 97, 30 mobiles has already been recovered by the police. That was written in the search sheet itself, Your Lordship. Now, that being the position, Your Lordship, I should have been, the disciplinary proceedings should have been dropped against me, but they did not drop it, Your Lordship.
Is it required?
Normally
Both are parallel.
parallel, but Honorable Apex Court has said,
Hmm.
but I am not on that, Your Lordship. Proceeding is going on, although I have put to challenge. But now, Your Lordship, my case is this, Your Lordship, that they have suspended me on 19th February 2025. Now, going by the dictum of the Honorable Apex Court in Ajay Chaudhary, Your Lordship, within 90 days, they should have,
Yes.
Your Lordship, issued the search sheet.
Hmm.
But the search sheet was not issued within 90 days. Now, search sheet was issued, Your Lordship will find it in the, at page 170, Your Lordship. Page 127, Your Lordship, of the, of my affidavit in reply.
This is suspension order.
No, Your Lordship, Your Lordship may kindly come to page 128.
Hmm.
24th June 2025. This is the search sheet, so cause notice under rule 9 of the Assam Discipline and Appeals was issued, Your Lordship.
So this is not within 90 days.
90 days, Your Lordship. This was, Your Lordship, the 19th February and it was 24th June. Now, if that be so, Your Lordship, as has been held by the Apex Court, as well as there is a series of orders from our High Court, Your Lordship, which has been clearly said that if once they fail to do so within 90 days, then I will have to be reinstated in service, Your Lordship. That's it. Even if they require to transfer me to some other place, they can, Your Lordship. But my reinstatement is, Your Lordship, is mandatory in case of failure to do so, Your Lordship. Now,
90 days from the date of suspension, show cause
Suspension.
notice has been.
yes,
to be
yes,
issued.
that is
And
the
statement of allegation and.
Lordship. That has been, Your
That
Lordship.
disciplinary proceeding has to start.
That's the disciplinary has
Still
to,
going on.
it is going on,
But
but
then
for
it has to start within 90 days.
90 days, Your Lordship. Otherwise, they will have to, before that, Your Lordship, if they cannot, Your Lordship, then they will have to reinstate me, Your Lordship. Now,
Fire charge sheet is a different chapter.
that's a different subject. But this is a disciplinary, even otherwise also, Your Lordship, there is the the ZM Tong case, Honorable Apex Court has held that if the everything is same, so far as the allegation in the FIR as well as the allegation in the disciplinary proceeding, witnesses are also same, then both cannot go together. That's the law that has been settled, but I am not pressing that, Your Lordship. Since disciplinary proceeding is going on, let it be completed, Your Lordship. I will participate. I have been participating, Your Lordship. Tomorrow also another hearing is fixed. But the point is, Your Lordship, that the law having been settled by the honorable courts. Now, Your Lordship, I will, and there is an office memorandum also.
But the disciplinary proceeding that is going on is wrong.
Yes, going on, Madam.
It's bad.
Well, like here, the submission of the protest.
Let me, দাদা মই শেষ কৰি লওঁ। আপুনি তাৰপিছত
আজিতো ফিনিছ নকৰে গতিকে ডেটটো দিব।
Your matter is not that long. It is over.
which one?
No, he said that he will take the entire day.
No, there is nothing to
Nothing more.
say more. I will reply. This is the office memorandum, Your Lordship, of the authority. Honorable Gauhati High Court had orders that so and so in a series of writ petition, the lead case being so and so has directed to issue notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India case to the effect that disciplinary authorities are to strictly comply with the requirement to issue memorandum of charge searched before the expiry of 3 months from the date of issuance of the order of suspension. It is therefore directed that all the senior most secretaries of all the departments shall ensure the memorandum of charge search is served on the delinquent officer employee before the expiry of 3 months of period from the date of issuance of order of suspension. They shall also ensure that currency of suspension order should not extend beyond the 3 months. If within this period the memorandum of charges search is not served on the delinquent officer employee. It's very clear their office memorandum. They cannot continue it if within 90 days they have not. And in fact, Your Lordship, there are certain judgments, Your Lordship, passed by this honorable court, Your Lordship. Okay. And I don't need to go any further, Your Lordship. I am just relying on these or judgments by the here in the first case, Your Lordship, by Honorable Justice Nayar, Your Lordship. This is WPC number 502 of 2025. Suspension was dated 31/2024. Then so cause was issued on 4/5/2024. And inquiry was concluded on 27th. Inquiry concluded, Your Lordship. Now, Your Lordship will kindly come to para 18, Your Lordship. Having noticed the said decision pertaining to the issue of prolonged suspension and the law declared in the matter in the case of Ajay Chaudhary and implemented by state respondents by issuance of office memorandum dated, Your Lordship has already gone through, 4/2010, this court is of the considered view that the respondent authorities cannot act in violation of the law as laid down in the case of Ajay Kumar Chaudhary, and it being a law declared under Article 141 of the Constitution of India, it would be binding on all concerned in the country. In view of the above position and admittedly the order of suspension of the petitioner not having been reviewed in terms of the direction passed by Honorable Court in the case of Ajay Chaudhary, this court is of the considered view that same has lost its force and accordingly same cannot be seen to be in currency any further. The petitioner accordingly would be required to reinstate in service, Your Lordship. That is there, Your Lordship. And in fact, Your Lordship, the facts, Your Lordship will get it at para 5, Your Lordship. No, para 3, Your Lordship. Then another judgment is there, Your Lordship, by Honorable Justice Manish Chaudhary, Your Lordship.
Same principle.
Same principle, Your Lordship, that Your Lordship will get it at page 9, para 9. Orally, Mr. Learned Counsel for the petitioner has contended that the order of suspension dated 28/11/2024 came to be passed by the respondent number 3 in exercise of power under so and so 64 rules, and the subsequent order of extending the period of that extended, Your Lordship, came to be issued only on 6/6/2025, Your Lordship, more than 3 months, whereby the period of suspension was extended with retrospective effect from 28/5/2025. He has pointed out that in between 28/11/2024 and 6/6/2025, the disciplinary authority and or the competent authority did not make any review of the suspension order within a period of 3 months from 28/11/2000, same as in our case, Your Lordship. And there was no reasoned order extending the period of suspension beyond the initial period of 3 months. He has submitted an even after memorandum of services prepared and served upon delinquent officer, it is still a mandate to review the suspension order within a period of 3 months to find out the necessary to extend the currency of order of suspension or not to pass vision order. He has submitted.
Within 3 months,
That will have to be
memorandum of charges has to be
given, and if not, then reinstatement, Your Lordship, is there.
Or if it was extended.
And so far
then
as
also it's a different.
Lordship, if it is subsequently extended, that will not, that will also vitiate the initial suspension.
So what do you say, Mr. Chitia?
Yes. Although my friend one of author who submitted that his submission is beyond details. He no way stated in the petition order regarding the Oyo Chaudhary case review for 3 months. In fact,
Achha.
we have reviewed it, but I have got the financial. We have reviewed it. And the family posting is going on. And so petitioner in the Lordship can see the pair.
No, first point is that it is outside the pleadings.
Outside of pleading, he has submitted regarding the review of the suspension period. The Lordship can see and pair person also. Pair person also never says. The nature of surgery appropriate direction like nature should be issued to clause the set aside suspension order. Should by that so when so suspended. This is a clause. And surgery shall not be issued. Should not be issued set aside the clause the suspension order. And 3 issued set aside clause the disciplinary proceeding to ensure that number 3 is the disciplinary proceeding. It is not a time to clause the disciplinary proceeding. Direction response number 4, paragraph 4, therefore issue not to give effect to the suspension order. And 5, respondent will reinstate the service original post of so where he has stated that as per Supreme Court order of the Chaudhary case, periodical review has not done nothing to which point in the repetition. But that point cannot be argued now. Now regarding the popular proceeding, the setting aside the popular proceeding. Setting aside the popular proceeding, petitioner has not categorically stated that is wrong and they cannot go for the popular proceeding going on. So the popular proceeding has drawn until it is concluded, my lord. Lordship would not interfere.
He has challenged a departmental proceeding. And on law point, it can be taken up.
No, but the popular proceeding is going on.
No, he has challenged because department.
The popular proceeding is but
Because memorandum of charges is issued late.
no, he has no materials to set aside the popular proceeding. Supreme Court cannot issue. I have today. I have not because the file has been handed over by the Rahul Dor just now,
No, your lordship,
and that's why this category decision is there. The popular proceeding cannot be interpreted by the Supreme Court. That lordship can only direct to complete it in expedition.
I will
If it is wrong, if
no,
it is wrong,
no, your lordship, I just want to
if
point
the
out.
proceeding is wrong, because the
Proceeding is not wrong, my lord. Why?
memorandum of charges were given later,
No, your lordship.
beyond 90 days.
No. Your 90 days, this is for reinstatement. This is not for the discipline proceeding. Disciplinary proceeding can be taken up in the latter part also.
He is correct,
we
your
have
lordship, to that.
we have issued a partial department under notification. That review can be done after within 6 months. That is not mentioned and not set aside. Praying for setting aside this department. Now department proceeding has been started. Is geared up. It cannot be stopped. And lordship only say that you are doing the department proceeding. Yeah, you do it expeditiously only because of that. Otherwise, lordship has no right to follow interfering unless it is the adverse.
What is this?
Beyond.
What a budget is it?
So it is as per law, their department proceeding is going on. So until and unless the department proceeding is concluded, I don't know the status of the department proceeding as of today. Lordship can give the time to I will obtain the instruction. What is the status of the department proceeding? His prayer person only to set aside the suspension order and the department proceeding. So suspension order on what ground the suspension order should be set aside. The department proceeding has already been started. So the question of suspension does not arise as on today. The department proceeding is going on, let it be completed.
Okay, departmental proceeding will go on and it will get completed.
Completed.
But as far as the suspension order, that cannot exist.
Suspension order, department proceeding, it is up to the department proceeding. Suspension order, review, suspension order is reviewed after 3 months. We have received the minutes. The last reviewed in 2017 November 2025. The suspension order 2004.
Reviewed then what? Extended.
Extended. That's why, madam. This point deeply has not taken in the news for the petition also.
This present suspension order was extended
Extended, madam.
before 3 months completion.
Yes, completion.
No, that's wrong, your lordship. Not before.
Last 17/11/2025.
Then
Even though it's not, this plea is not taken in the deed petition. He cannot go. He cannot plead beyond this or pleading. That was not taken into
If
which
it is
point.
extended, then
So-
was,
Extended, my lord.
Not within 3 months, your lordship.
Whatever may be, they are not challenging this. They are not challenging it, my lord. Yes, even though not 3 months, they are not challenging. We have done it within 6 months. As per our
not 6 months. You have to.
no, beyond 3 months, but we have an other notification also there, but they have said you have to go for the date of suspension within 6 months, you have to review it. According to
That
we have
memorandum also speaks of.
I
We
speak
did
of
6
3 months,
months,
but yes, after 3 months, we have reviewed it. First order 26 June 2025, the second order, and the third order, I think,
No, within 6 months, you see, after issuance of memorandum
No,
of charge,
sir.
why not issuance
the
of
senior most secretary shall undertake a review within 6 months as regards the desirability to further continue. So this is after issuance of memorandum.
whatever maybe where he is pleading. Lordship, kindly see where is the pleading is there for reviving
These
the
law points.
No,
No, law point is
why
there,
should
but
I
whatever
plead,
maybe,
your
he has
lordship? I
taken his
cannot
plea.
plead,
He
your
does not
lordship.
know, madam. He has not challenged the review order. We have reviewed it several times, madam. Last order has been filed in November 17. November 17, November 2025, it is extended. And beyond that also will be extended.
Extended where?
17 November 2025, last.
17 November 25.
Last order I have received. But beyond that, I may be the order in the month.
No, that is suspension extended.
Suspension extended.
And when is the suspension given here for the first time?
Yes. February 2024.
Suspense was made, Your Lordship, 19 February 2025.
19?
February 2025.
Why?
I was suspended.
Last order, not November.
So this is not, this is beyond 3 months.
No,
This is
madam.
much beyond 3
No,
months.
no, other order is there. Other order is there.
Other order, Your Lordship will get it at
In the
page
month of June.
131, 26 June 2025. That is also marks after 3 months. Your Lordship.
26
February, March,
25, 3 months. And then again, my lord, in the minute.
21st, 6th of June.
26th of June, Your Lordship, page
And
130.
4th
This is the,
September 2025.
after a lapse of 3 months, Your Lordship, this is the next time.
Fine.
Proceeding will go on, Your Lordship. That will not vitiate the
So
proceeding.
let the disciplinary proceeding go on, but then suspension order will have.
So that cannot be say other Supreme Court order is also. Today I cannot say that one order is there, but I will have to go through it because
I'm taking it for disposal.
it was dealt with by the Rahul Dharma relationship. Now he is in ballot on next. That's a file sent to me. By
You are much senior.
no, my lord, I can do it, but I will have to go through it. Without going through it, my lord, I thought it, my lord, I would take time. Because, my lord, even now, my lord, they are not taking any plea regarding this, my lord, restatement on the basis of that. I have gone through the petition.
You either decide to take time or you either decide that
Yes, some time may be granted.
argue fine.
And I will argue the path. I will have to go in voluminous report, but I cannot go through within 5 minutes.
Not voluminous. So what to do, Mr. I was thinking to dispose of this matter.
No, my lord, it cannot.
Your
be,
Lordship may take it up tomorrow, Your Lordship.
Not tomorrow, I cannot do it. Next week, my lord, I will prepare. I will come with PPR along with up to the status.
Your Lordship is hard at length, Your Lordship may keep it as a part.
No, not hard.
So Your Lordship has hard it at length, Your Lordship. This has been pending, Your Lordship.
No,
That's my fervent prayer, Your Lordship.
My health condition also, you know, I don't keep anything part. So
And if somehow Your
Yes,
Lordship
so-
cannot take up, then it's different matter, Your Lordship. We,
next week, Lordship, please, I will argue the matter. If they have to color, I will argue the matter. Otherwise, Rahul Rao will appear. He's
but,
looking at the.
I mean, you decide finally, I mean,
Yes, ma'am.
you look into the facts properly.
Yes.
And you look into the, also the fact that it is within 3 months. This has to be extended or your memorandum of charges has to go.
Yes, sir.
6 months and all will not do. 6 months after memorandum of charges.
6 months of the notification is there, our notification is there. It's circulated to all the officers.
Okay, as a, what
To
Mr.
collect-
As Thakur, learned counsel for the petitioner and Mr. T.C. Chutia, learned standing counsel for,
I am a government project.
learned government advocate. As prayed for by Mr. T.C. Chutia, this matter again. On, next week,
Yes. Next week.
31st of March,
Yes.
2026,
The first
Tuesday.
Tuesday.
as part head, Your Lord.
Okay, partly heard.
No, I cannot say because my matter is dealt with by the Rahul sir.
Huh.
Now today I am appearing before the Lordship. Tomorrow I may not appear.
Partly heard
This-
again for orders. For further orders.
Yes. Yes.
Free count
Yes. Okay, first problem.
on 31st.
Take problem.
Take your,
Yes.
listing your thoughts and these judgments and the memorandum, let it be in the file.
Lordship. Deeply obliged, deeply obliged.
May I believe? Order dated 17/11/2025 of the service is completed.
Yes, on respondent number 6.
My
So, Ms. Chaudhary, you are ready?
Also, I have got 3, 4, and 5.
Uh-huh. 3, 4, what about others? What, you're ready to do the matter or something has to be done?
Which recommend 6 for admission.
admission.
Yes.
Admission.
Readings are complete.
Complete.
What complete? There is no affidavit here. Or only oral instructions will do.
No, Lordship, this matter was, service was awaited against respondent number 6.
And
No, 6 is complete.
complete.
Completed.
Oh, no.
6 is complete. And then what about others? 1,
Other respondents are there.
JK
Social welfare, Assam is there.
3, 4, and 5, you are appearing.
Yes, sir.
6 is complete, so service is complete. It is noticed from the office note that service in respect of all the respondents are complete. And then the matter will be taken up for admission hearing. On which date? You will not file affidavit.
Lordship, file was not traceable in. So we have not getting the file, Lordship.
What are you,
It's
sir?
a-
What
Copy
about- Okay, now let-
of the request.
now we'll let the matter be taken up. Ms. Chaudhary, learner counsel for respond number 3, 4, and 5. Submits that she does not have the copy of the petition. As such, it is directed that the learner counsel for the petitioner may serve her a copy of the petition. List this matter again on. You see the copy, then you decide whether.
Lordship, other respondents, respondent number 6, service completed, but
Service
no one is there. Lordship.
representation.
That may be recorded also.
No, all are completed. Let's see what happens next. Is this matter again on? Then
29-4.
Huh?
29-4.
29th of April 2026.
Obliged.
Yes,
Content matter, Lordship.
content.
Lordship.
Service report is awaited.
So as far office, no, we did answer notice, received that.
No ID card and answer notice. Shri Mamata Hojai, what happened? Why can't you serve?
We should have taken step.
She is retired or what? Yes, Mr. Any government advocate? Yes, you are there.
Yes, yes,
You are there for the director.
yes, yes.
Mamata Hojai.
Yes, Director Secondary Education Department.
Achha. So, what has to be done today?
On next date, I will file our Balanama, the instruction regarding that matter.
Third miss,
And
Yes,
it may be sent to us. Madam.
copy. Third miss S. Majarmia.
S.R. Major.
S.R. Majarmia, learned counsel for the petitioner. Mr. Your name, please.
You, Sharma?
Mr. U. Sharma, learned counsel, has entered appearance on behalf of the sole respondent. And he submits that he will file his wakalat, that he has instructions to appear for the said respondent and he would like to file his wakalat number. Prayer is allowed. Further, it is directed that the learned counsel for the petitioner would serve him a copy of the content petition. List this matter. After 2 weeks on a date to be fixed by the registrar. List this matter on 27th of April. Okay?
Yeah, please.
Yes.
Do you contact application
Hmm.
or?
Order has been complied with, madam.
Order has been complied with.
Our case was rejected, madam.
I mean, yeah, did you give him a copy?
I'll give, madam.
I will challenge, madam.
Huh?
I will challenge, madam, this one.
No, as far as this content application goes, this will be closed.
Oh, yes, yes.
Then you challenge. it,
Yes,
not
yes, yes.
proceeding, it's okay.
Yes.
Heard, Mr.
D. Gogoi.
D. Gogoi, learned counsel for the petitioner. And Mr.
NJ Kaplan.
N.J. Khatamia, learned counsel for respondent number
1 and 2.
1 and 2. by this application? Filed under section 12 of the Contempt of Courts Act 1971 and Article 215 of the Constitution of India. The petitioner has alleged willful disobedience of the order dated 30/5/2023 passed by this honorable court in writ petition number 2912 of 2025. By the full stop, by the order dated 30/5/2025. This court had directed the respondent authorities to consider the case of the petitioner for compassionate appointment. It is also directed that the respondents, particularly the state level committee, shall reconsider the case of the petitioner in the next sitting of the committee. However, when the matter is taken up today, the learned counsel appearing for respondent number 1 and 2 has placed an instruction and has placed a speaking order issued by the Secretary to the Government of Assam,
Department of School Education.
Department of School Education, wherein it is stipulated that the proposal submitted by the petitioner for compassionate appointment was placed before the district level committee in its district level committee Lakhimpur in its meeting held on 10/8/2011 and 21/11/2012. But then this order was of 2025. You have to reconsider.
Yes, madam. The problem is that on 10/8/2011 and 21/11/2012, case was placed before a DLC. It was not recommended. But in subsequent petition, it has been stated that her case was recommended. Due to the fact that there were one Meenakshi.
Yes.
Meenakshi, there were two candidates in the same name, So that the case of that Meenakshi was considered. So it was wrongly submitted before this honorable court that her case was considered. So when this time it was placed before the SLC, that fact came into knowledge.
So when was it placed before the SLC?
It is placed on kindly come to last, but before decision, fourth line, A comprehensive scrutiny of all records conclusively established that the petitioner was never recommended by the DLC at any stage, and the only person ever recommended was different individual of similar name. The petitioner case has thus remained ineligible throughout, having left under the applicable guidelines. So, and then decision in view of the fact and circumstances detail above, it is hereby held that the compassionate appointment claim of Srimati so and so cannot be exceeded to, and as her proposal was never recommended by the district level committee and further stood lapse due to non-availability of vacancy within the 5% ceiling and expiry of the permissible period under the government guidelines.
These are all prior to the direction given by this court in 2025. This must have been taken note of.
This is still rejected in the WBC number WH07 of 2019, whereby directing to reconsider my case. But this order is not followed. There is a 2-week petition.
What is this 22/11/23 order?
This is earlier, madam.
When my lord, this order has not been completed, we have again filed, my lord, the petition. My present.
It's already one, so I'll consider it at two or what? You will bring further proper instruction?
Yes, my lord, that will be better, I think.
Because these all speak of prior things, so
Whether-
after 2025.
Whether subsequently it was placed before the SSC, that has not been reflected in the speaking order. That instruction I will have.
Had placed an instruction. Minutes. However, we are not counsel for the respondents placed an instructions. It was you, placed an instructions by Secretary of Secretary to the Government of Assam Department of School Education in the corner. In its meeting held on 10/8 and 21/11 corner. 21/11, and that on both the occasions, her case was not recommended. And that there was a further mistake in respect of the name, which was recommended, but which was not of the petitioners. However, after 2025, however, after the court's order dated 30/5/2025, the Learned Counsel for Respondents is not aware as to whether the case of the petitioner was further reconsidered by the district level committee. By the
Exception, by direction was.
by the
considered by the
state level committee. Accordingly, he seeks some time to get the proper instructions. Accordingly, list this matter on when? List this matter on
Immediately after the.
on
20.
or before due. We cannot be.
Before.
List this matter on 22nd of April.
22nd.
Look,
Of
27, my lord, except 27, my lord, 23rd,
22.
23rd.
What are the other matters left?
Deplorable.
Obliged.
41, 41.
41, yes.
Contempt lawsuit, non-compliance.
Some reports are there.
The hearing was completed on 17/7/2020.
Then I'll take it up at two. If I have to see. I'll take it up at two.
So, my lord, instruction is required here, my lord, because here secretary has written to the director and requested to fix the inter-seniority on the basis of.
Bring some further directions.
Yes,
Okay, heard, Mr.
you, Sharma.
U. Sharma, heard, Mr. U. Sharma, Learned Counsel for the respondent,
Yes,
prays for some further time to bring proper instructions in the matter.
yes.
Here is allowed, list this matter, you have heard, no, yeah. List this matter on, when?
After being,
List this matter on 29th of April.
yes.
What about the other matter? Already
There
is a hearing.
was a direction, though it is listed in hearing parameters, there was a direction to file an affidavit regarding some queries. And I have received the instruction, but I need 2 weeks time to file affidavit. Actually, after petition also.
You are assistant SGA. Mr. Yes, Lampert, learned assistant SGI, prays for some further time to file the affidavit in the instant matter. Prayer is allowed. List this matter when?
My lord, let's fix to. On April 23rd
23rd of April,
or 24th also.
24th of April, 2026. Further, the matter may be listed for orders instead of hearing.
Admission.
May be listed for admission.
Deplorable.
This is exhaustive.